Hello you guys, and welcome to the down payment class. We're going to go over a lot of things today, so make sure you have your notes and your pads ready. We're going to go over everything that you need to know in order to get your down payment back. You are going to be going through arbitration, so these are the claims and defenses that you're going to use, the laws that you're going to use, and the most important things that you're going to need to know when it comes to getting your down payment back. So let's get into it. The disclaimers: I am not a lawyer, attorney, or accountant. I do not give legal advice. If you need legal advice, contact a lawyer. I have to say it. Things that you need to remember: foundation is key. That's just what it is. Foundation is key. In order for you to get to a place where you can, fight financial institutions and credit reporting agencies and companies in general by yourself, you're going to need to study. Foundation. Read everything you submit, receive, and sign. So it would behoove you to get your contract while we're here and highlight all of the violations that we go through. Go over your contracts and highlight all violations along with the laws that back you up. Always complain to more than one agency. For the governmental agencies and companies that govern these companies, you want to complain to more than one person. Always address your disputes to a person. A lot of you, especially when it comes to billing errors, which this is not about billing errors, it's specifically about down payments. When it comes to billing errors, a lot of you guys address your complaints to, the billing department or whatever the case may be. And if that is the case, you can still do that, but you can still attention to someone else as well, whether it's the CEO, the CFO, whatever the case may be. And you're going to find that on those 10K and 8K forms under the Security Exchange website. Requirement versus violation. This is important when it comes to forming your claim and stating your claim, because I know a lot of people, when they first started out, I know I did, I started with the United States codes. And then as I got more, in depth with my research, I got into the CFRs and I got into the UCCs. And I realized that there were a lot of different laws. And it was a lot. But for this specifically, you're going to have to understand the requirement versus the violation. And you're not going to fully understand the USCs until you go to the CFRs, and the CFRs kind of break it down a little bit more in depth, which we'll go over later on in the video. So the requirement is the CFR, and the violation is the USC. The CFRs are the rules that the company must follow, but they cannot violate a CFR. They simply just fail a requirement, but they can be used to help you build your case. It is still a requirement they must uphold. The USCs are the laws put in place that the company has to abide by, and if they do not, they are considered violating the law. But keep in mind, a violation is not a claim. So these are going to be really, really important to understand when it comes to forming and stating your claim, but this alone is not a claim, and we're going to go over how to properly state your claim later on in the video. How do I know if my contract is subject to TILA? This is really important because if your contract is not subject to TILA and TILA doesn't govern that contract and the dealership, then you have no case. You can't go after them for a down payment under TILA if the contract is not even subject to TILA. So the main things that you can look for in a contract that is, governed by TILA is the contract says the seller is the creditor. Okay? The contract says it is governed by TILA. The contract says consumer credit contract, or it has that H1 credit sales model form inside of it. And once I pull it up, you guys are going to know exactly what that is, especially if you have a car contract. We're going to go over that later on as well. The finance charge. So let's get into it, right? The finance charge is really going to be one of your main claims, right? Them misrepresenting the finance charge, right? Because if the down payment was included in the finance charge, because on my boyfriend's contract, the down payment was actually included in the finance charge, but he still paid out of pocket for it. Crazy. Crazy. Like, total violation of his rights, right? If the finance charge is the sum of all charges, and that is the credit amount that the financial institution is going to give you, why would I pay if the finance charge, if you're saying that it's included in the down payment, if the down payment is included in the finance charge, why am I paying cash out of my pocket for a down payment if it was included in the finance charge? Okay? But this is why it's super, super important to receive your contracts, because the contract that they gave you may not be the contract that they sent over to the financial institution. So keep your original paperwork all the time, because they're committing not only securities fraud, but dealer fraud as well. Okay? But, and also, if it's not in, okay, I gave you that scenario. But what if on the extra fees, the down payment, it said that it was the down payment? That, okay, either way it goes, whatever way the coin flips, it's a violation of your rights, because if the financial institution required it, right? Why am I paying it to you and not the financial institution? If the financial institution said they required a down payment, why am I paying the down payment to the dealership and not the financial institution? That makes no sense. But we're going to get into it, y'all. Let's look at the definition of a finance charge. Okay. Except as otherwise provided in this section, the amount of the finance charge in connection with any consumer credit transaction shall be determined as the sum of all charges, payable directly or indirectly by the person to whom the credit is extended, and imposed directly or indirectly by the creditor as an incident to the extension of credit. The finance charge does not include charges of a type payable in comparable cash transactions. So, once again, when you have a finance charge in place, you're not supposed to pay a down payment. For one, there's not supposed to be any cash included within that finance charge. So if, once again, your contract says that the down payment was listed in the finance charge, or a breakdown of the finance charge, you're in violation because you took cash for that. When it says here in a finance charge, it does not include charges of a type payable in comparable cash transactions. And then, once again, if you didn't include it in the finance charge, or the dealership didn't include it in the finance charge on your contract, they're still in violation, because if they said it was required, which they did tell you, because I promise you 9 times out of 10 they're going to say the financial institution required it and not them, they're still in violation, because if it was supposed to be included, then it should be in the finance charge. So either way the coin flips, it is still a violation of your rights. These are the things that that are applicable, right? This is a really, really important one, because they'll tell you in one of the rebuttals, which we'll get into, they'll tell you that, oh, insurance period wasn't included. Insurance wasn't included. That's not what the law says, right? It says life, accident, or health insurance premiums included in finance charge. Okay, let's get back into it. Remember when I told you, in order to really understand the USCs, you're going to go to the CFR as well. So we're going to just take a look at finance charge definition under the CFR. Okay. The finance charge is the cost of consumer credit as a dollar amount. And we just read the definition of a finance charge under the USC, but remember, when you look at your contract under finance charge, it says the dollar amount the credit will cost you, and we'll get into that definition as well, because the law says that that's what they have to say on there. And that's where you get this from as well. So it's the same. They all work in conjunction, but like I said, it's going to be a little bit different in between the two, because this one's going to break it down a little bit more. So this is where you're going to go to get the breakdown of a finance charge, examples of finance charges, things like that. And B8, premiums or other charges for insurance against loss of or damage to property, or against liability arising out of the ownership or use of property written in connection with a credit transaction. So once again, when they tell you that insurance is not included, take them to either 15 USC or 12 CFR 1026.4. And all of this, you did receive a PDF form as well, because all of these are links that you can click on. Charging a down payment where no cash should have been included is a violation of TILA. Let's go here, right? Well, let me finish. For misrepresenting the amount financed, if the bank required a down payment, it should have been included in the finance charge. Well, let's look here, though, at A2A, because this is another one. So, 15 USC 1638, transactions other than under an open-end credit plan. Now, if you know me, you know I talk about your open-end credit card, which is your credit card, which is your social security card, right? But this says transactions other than under an open-end credit plan, which this is, right? Even though your credit card is unlimited and that's what you use to fund the transaction, you got yourself into this is a closed-end credit plan. And what a closed-end credit plan is, a plan that it's like a loan, right? It's not revolving every month. You don't get it every month. Once you pay the loan off, it's done. Okay? Required disclosures by a creditor. The amount financed, using the term which shall be the amount of credit of which the consumer has actual use, this amount shall be computed as follows, but the computations need not be disclosed and shall not be disclosed with the disclosures conspicuously segregated in accordance with subsection B1. Okay, so they have to give you a specific disclosure when it comes to the amount financed. And these are the things that's going to be in here, right? Required disclosure. So you can go down this whole thing when you have time and read through everything that they're supposed to disclose to you. This is everything that they have to let you know. And a lot of these things are probably not in your contract. The amount financial in term, which shall be the amount of credit of which the consumer has actually used. I'm rereading it, y'all, because I feel like I wanted to say something else on this. I wanted to elaborate on this really quick. Okay. All right, let's get into the down payment itself, right? First of all, like I said, who requires the down payment? If you call your financial institution and ask them, did they require a down payment at the time you bought your vehicle? They will tell you no. Even if the dealership told you yes, that this is what it is. That's their actual normal procedures. When they sit you down, they say, hey, so-and-so approved you, but they need so-and-so, but they need this much down. A complete lie, like a complete lie. But let's get into the USC and the CFR when it comes to advertising of down payments, right? Okay. Advertising of down payments and installments. No advertisement to aid, promote, or assist directly or indirectly any extension of consumer credit may state that a specific periodic consumer credit amount or installment amount can be arranged unless the creditor usually and customarily arranges credit payments or installments for that period and in that amount. That a specific down payment is required in connection with any extension of consumer credit unless the creditor usually and customarily arranges down payments in that amount. They're not supposed to be advertising down payments. Let's go to the CFR, right? Advertisement of terms that require additional disclosures. Okay? Whenever certain triggering terms appear in credit advertisement, the additional credit terms enumerated in 1026-24D2 must also appear. These provisions apply even if the triggering term is not stated explicitly, but may be readily determined from the advertisement. For example, an advertisement may state 80% financing available, which is in fact indicating that a 20% down payment is required. So triggering terms. If any of the following terms is set forth in an advertisement, the advertisement shall meet the requirements of paragraph D2 of this section. So what are the triggering terms? Only 5% down, as low as $100 down. Total move-in cost, $800. The provisions apply only if a down payment is actually required. Once again, when you walked into that dealership, they told you a down payment was required, right? That the financial institution required a down payment. But when you called that financial institution, call your financial institution now, even after you have the car, and ask them, did you require a down payment? They're going to tell you no. Is that not false and misleading? If down payment is actually required, statements such as no down payment or no trade-in required do not trigger the additional disclosures under this paragraph. So anything under no down payment or no trade-in required, they got to explain. Okay? All right, let's get into the contract, right? Let's get into your contract, y'all. And the first thing we're going to do is understand, we're going to look at the definition of a consumer credit contract, because in order for you to understand that your contract is a consumer credit contract, I know it 9 times out of 10 it says retail installment contract. It's a consumer credit contract. We're going to look at that definition. Any instrument which evidences or embodies a debt arising from a purchase money loan transaction or a finance sale as defined in paragraph D and E of this section. So it's an instrument that evidences or embodies a debt arising from a purchase money loan transaction or a finance sale. Did you not finance your vehicle? This next one we're going to get into, because preservation of consumers' claims and defenses, unfair and deceptive acts or practices. So this is going to be really important, because once again, one of the things that they're going to tell you in the rebuttals is that, oh, we don't, we're not the creditor, or we're not the seller, or we're not the holder of the contract, right? And they're going to say that to get out of this 16 CFR 433.2. In connection with any sale or lease of goods or services to consumers in or affecting commerce as commerce is defined in the Federal Trade Commission Act, it is an unfair or deceptive act to practice without the meaning of Section 5 of that act for a seller, directly or indirectly, to take or receive a consumer credit contract which fails to contain the following provisions in at least 10-point boldface type. What does it say? A consumer credit contract, which states this: some of your contracts may have it, some of the contracts may not. But depending on whatever institution that you're dealing with, if they have it, okay. If not, this is the law that they're violating, because it's a CFR. This is the requirement they're failing to meet right here. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. Okay. Let's kind of break this down, right? I want to get into the debtor, right? Because I know you've heard you're the original creditor. And even though we know, okay, in fact, you are the original creditor, Congress doesn't define the original creditor to be you, right? They don't really define original creditor at all. They don't define it to be you, though. Not only that, you want to be the debtor under TILA. Under TILA, you are the debtor, right? Because what does it say? The debtor could assert against the seller. You didn't sell anything in this transaction, right? The dealership did. They sold you the car. The seller of goods or services obtained pursuant hereto or with the proceeds hereof. The seller. Let's talk about the seller, because that's another thing that the dealership can say, right? Okay, we're not the creditor, we're not the holder of the contract. Okay, but you are the seller, though. And they're subject to the same claims and defenses as the holder of the contract and the creditor, which they are the creditor. And we'll get into that as well. Okay. All right, that H1 credit sale model form that needs to be within your contract. And it is, it is right here. So this part right here, this tubular part right here, this is how you know if once again, your contract is subject to TILA. But look at this though. The dollar amount the credit will cost you. So why do they have a different number here, here, and it's another one they have a different number on? Why do they have different numbers up here if the finance charge is literally the sum of all charges? But I want you to look here. The dollar amount the credit will cost you. So the dollar amount the credit will cost you is the sum of all charges. So everything that it's going to cost me to leave here with this car today, it should be in the finance charge. I shouldn't be paying any cash in connection with the finance charge. If my contract says a finance charge is involved, I should not be paying any fees. It should be in the finance charge. Okay. Here's the insurance. And then I showed you where to look for when it comes to insurance, as far as the types of insurance as well. Okay, and then let's go to the CFR's definition of a finance charge that's located on the H1 model form. Finance charge. A finance charge using that term in a brief description such as the dollar amount the credit will cost you. So that is, this is why they have on that H1N1 form this description right here, because this law tells them that they have to. Okay. All right, stating a claim. In order for you to bring forth a claim, the company has to be civilly or criminally liable under TILA. You can't just say they violated you. Once again, your contract may be different from the next person's contract. So the way that I teach is going to be foundational, right? It's going to be used for you to build your case and everything that you need to know off of what you know they can and cannot do, what you know your rights are, and then all the violations. You can state your claim from there. You can't state a claim that's not true, because once again, where was it? The consumer's claims and defenses may have been in your contract, and then it may be another one of you who didn't, right? So when it comes to stating your claim, this is really, really important, because if you don't state a claim properly, your case will be thrown out and deemed as frivolous. So let's go over civil liability and criminal liability. Civil liability is a legal obligation that requires a party to pay for damages or to follow other court enforcements in a lawsuit. Then you have criminal liability. You are likely to be held responsible for breaking the law, whether it be potential or actual responsibility. Criminal liability is considered to determine whether a person will be charged and sentenced. So civil liability, they have to do an action, or, pay some money back, or, they're more than likely financially responsible to you or liable to you. When it comes to criminal liability, this is when the law says, no, you're going to jail for this. You ain't paying no fine. You're going to jail. Okay. Failure to state a claim. Failure to state a claim is a defense asserting that even if all the factual allegations in a complaint are true, they are sufficient to establish a cause of action, and the case should be therefore dismissed. Pay attention to cause of action, because like they said, even if everything that they did to you was factual, where in the law can you point them to say, well, this is where they're liable under me, and this is where my relief is, which we'll go over where your relief is later on in the webinar. 15 U.S.C. 1640, civil liability. Except as otherwise provided in this section, any creditor who fails to comply with any requirement imposed under this part, including any requirement under section 1635 of this title, subsection F or G of section 1641 of this title, or part D or E of this subchapter with respect to any person, is liable to such person. So this is where your the civil liability is going to come at, right? And then we're going to go over that in a little bit. Under there is where you're going to get your relief, right? They're going to tell you what would be owed to you if they are civilly liable to you. In order to state a claim, you must have both the requirement and the violation within your claim. If you do not properly state your claim, it may be thrown out and considered frivolous. Also define each role. Remember when we went over, you're the debtor. Yes, you're the debtor under TILA. The financial institution is actually the holder in due course, because they're the ones trying to collect payment from you. The holder in due course is the one that is has the rights to enforce the instrument, and then the dealership is the seller and the creditor. Okay, and we're going to get over that. We're going to get into that later on in the video. So we went over 16 CFR 433.2. If the dealership is a holder of the contract, they are subject to all claims and defenses. Same thing with the seller. they're the seller, they're subject to all claims and defenses. If that is not stated, right, that could be fair, that can be unfair and deceptive if it is not disclosed within the contract. So if that, if this is not in your contract, that can be unfair and deceptive. How would I know that I have rights to insert if it's not on the contract, if it's not on the face of the contract? Right, let's get into it. Relief. Here's where your relief is going to come in at, right? 15 USC 1640. And I'm going to bring up monetary relief and equitable relief because there's a difference in the two. Monetary relief, as used in this section, the term monetary relief means damages, costs, attorney fees, and other form of monetary payment. Equitable relief is distinguished from remedies for legal actions in that instead of seeking merely monetary damages, the plaintiff is seeking that the court compels the defendant to perform a certain act or refrain from a certain act. So that is the difference between monetary relief and equitable relief. And 15 USC 1640, we're going to do that. We're going to get into the civil liability and where your relief is, because this is where it is, right? This is where your relief is, okay? Either it's going to be any actual damages sustained by such person as a result of the failure, or you're going to find your relief in here, right? Remember, everybody's contract may be different. The way one dealership or financial institution violated you may not be the way that they violated someone else. So it's either going to be the actual damages sustained by a person as a result of the failure, or you're going to go in this section and find your relief, right? So let's go back over that claim, right? So we're going to do ABC dealership failed to meet the requirements of 12 CFR 1680, which is in violation of 15 USC 1630, and is civilly liable to me under 15 USC 1640. And I'm seeking out my relief under 1640, which is one of the two that I showed you. One of these. All right, let's get into pushback, because a lot of the times everything that we covered, the insurance that was supposed to be included, the finance charge, your contract, how it's supposed to look, everything like that, they're going to give you pushback. So these are some of the things that they're going to say, and this is going to be how you combat it. According to the agreement, you promised to pay. First of all, you did not promise to pay anything under a contract full of violations and lack of full disclosures, and you must show proof of the TILA violations within the contract. So even though these are violations that happen to a lot of people, if it didn't happen to you, don't say it, right? So you still have to do your due diligence. I'm leading you in the right direction as far as stating your claim, what the violations are, the laws to go to. But in your contract, you're going to have to highlight everything, and you're going to have to show proof of the TILA violations yourself. Once again, insurance is one of the most common violations within your car contract. If insurance was needed to drive off the lot, it was supposed to be in the finance charge. In addition, you must receive a description of the insurance and sign off on this optional insurance to waive or accept it. So let me finish, because we're actually going to get to that later. One type of insurance that is supposed to be optional is property insurance. When you call the financial institution, ask them if property insurance is required. If it is required, it's supposed to be in the finance charge. If it was not included in the finance charge but required, it is a violation of 15 USC 1638. Okay? They gave you a loan. Okay. Let's see what the CFPB says. Okay? Once again, right? Your contract says retail installment contract. Is this a loan? A retail installment sales contract agreement is slightly different from a loan. Doesn't matter if it was slightly, doesn't matter if it was 0.2% different. Okay? It's different from a loan. So it's not a loan. They are in violation of 15 USC 1681 S2 for false and inaccurate information. Let's look at that law really quick, y'all. Responsibilities of furnishers of information to consumer reporting agencies. So, you're wondering why responsibilities of furnishers of information to consumer reporting agencies, why are we looking at this when we're talking about, getting our down payment back? Well, when you go on your consumer report, right, it says that you have an auto loan. But your contract says retail installment contract, and the CFPB says that's different from a loan. So why on your consumer report does it say that you have a loan? Okay. Duties of furnishers of information to provide accurate information. Reporting information after notice and confirmation of errors. The information is, in fact, inaccurate. So you want to get your, which I don't recommend getting your auto loan, especially if you're up to date with it, removed off of your consumer report, just so you can build your credit. But if it's a derogatory auto loan, here you go. They're reporting inaccurate information. They said that I got an auto loan on my consumer report. I just sent you in my contract. It says a retail installment contract, and the CFPB tells me that that's different from a loan. False and inaccurate information. They have to delete it if it is in fact inaccurate. The CFPB says it's in fact inaccurate. Okay. Go to the next one. They are not the creditor. This is often stated so they aren't held liable under TILA. The creditor must be stated according to 15 USC 1638A1. So let's look, right? Transactions other than under an open-end credit plan. Required disclosures by creditor. The identity of the creditor required to make disclosure. 9 times out of 10, honestly, on the face of the contract, it tells you that the dealership is the creditor. They have it on there. But if they don't, let's go to CFR 433.1 that says they are the creditor. A person who, in the ordinary course of business, lends purchase money or finances the sale of goods or services to consumers on a deferred payment basis, provided such person is not acting for the purposes of a particular transaction in the capacity of a credit card issuer. So, in the ordinary course of business, lends purchase money or finances the sale of goods or services to consumers. That's a dealership, y'all. They're the creditor. This is another one. They don't fall under the FTC holder rule. If your contract has the holder rule in it, they are either the seller or holder, and the rule states that both people are subject to the claims and defenses of the consumer. Now, if the bank says they are not subject to the rule, they would have to be a holder in due course and subject to the same claims as the seller. If they say they are not a holder in due course, they have no right to collect any amount from you. But let's look at this. Let's look at 16 CFR 43.3. Exception of sellers taking or receiving open-end consumer credit contracts before November 1st, 1977. So they might say, okay, well, I don't have to follow that because of this rule here. November 1st, 1977, from the requirements of subsection 433.2a. I'm sure every contract that we're in 2023, okay? Before November 1st, 1997, these rules would be in place if you have a contract from before this year. Then this would be current. Let's go to the next one. Pushback. Insurance was not supposed to be included. If the insurance was optional, there still had to be a disclosure regarding that. So if they did not disclose that to you, they are still in violation. State law almost always requires property insurance. But let's go back to disclosures for insurance. We are going to go to D. Insurance and debt cancellation and debt suspension coverage. So a lot of the times, 9 times out of 10, they're going to get the credit life insurance correct. But there's other insurances that you're going to have that have to be disclosed to you, so you can either accept them or waive them. So this also has to be in your contract, unless if it's not, it's a violation of not a violation, I'm sorry, it's a requirement of 12 CFR 1026.4, and they fail to meet that requirement. You agreed to pay, and you in fact did pay, right? So let's look at 16 CFR 433.1, consumer credit contract. Let's look at that again. Let's close some of these tabs so don't start going slow. Any instrument which evidences or embodies a debt arising from a purchase money loan transaction or a finance sale as defined in paragraph D and E of this section. All right, keep that in your mind, right? Let's go to 12 CFR 360. Okay. Financial asset means cash or a contract or instrument that conveys to one entity a contractual right to receive cash or another financial instrument from another entity. So when you signed that contract, you gave them a financial asset. That's what you gave the dealership, a financial asset. Now let's go to 26 CFR 15A. Let's go here. Let's go 3, payment. Okay. Payment may be received in cash or other property, including foreign currency, marketable securities, and evidences or indebtednesses which are payable on demand or readily tradable. Was that not the definition of a consumer contract? Was that not evidence of a debt? Purchase or evidences of indebtednesses payable on demand and readily tradable. Treatment as payment, in general, a bond or other evidence of indebtedness, hereinafter in this section referred to as an obligation issued by a person and payable on demand, shall be treated as a payment in the year received, not as installment obligations payable in future years. In addition, an obligation issued by a corporation or a government or political subdivision thereunder. In what this is saying is that your evidence of indebtedness, that contract, that financial asset, paid for your car. Pay for your car. Financial asset. Let's go back to financial asset. Means cash or a contract or instrument that conveys to one entity a contractual right to receive cash. So let me kind of break this down a little bit more, right? Because you're like, well, if it's an evidence of indebtedness, how did it pay for the car? How don't I owe any money on it? For one, your social security card is your opening and credit card that funded the transaction in the first place. When you signed your signature, you gave them money to get that. You gave them the dealership permission to get that money. Isn't that what the financial institution told the dealership? I'm sorry, isn't that what the dealership got from the financial institution? They got cash. That contract was just as good as cash. And then the financial institution bought it because now they're going to put your security, which is that contract, on the stock market, and they're going to make money from it. But then they're going to request money from you as well. So the dealership got paid on the contract, and they get paid every time they run your credit. So they told you they were only going to run your credit one time. They lied, because each application that they ran, they got paid from. And then your financial institution also got paid because they accepted the contract. And they're going to use that contract, and they're going to keep selling that contract over and over and over and over again. And they're going to keep taking money out of your trust. Make this make sense, right? Financial asset. How could a contract be a financial asset? Just think about if you have a business, just think about it, right? If you sign a contract with somebody, how is that an asset if you're in the business of loaning people money? Or you're supposed to be in the business of loaning people money? How is a contract a financial asset? If you just put up all of this money and you say, hey, I'm going to give you $20,000 to get this car, how is that a financial asset? Because you're thinking about it in the wrong way. To us, it's not a financial asset because we just got into all this debt, and the financial institution just fronted me all this money. So how is it a financial asset to them? Because it's not. I mean, because it's not a financial asset. To me, it's a financial asset to the bank and to the dealership. Because once again, when you sign your name on any document, it becomes a security. Your signature is very, very powerful. So let's kind of go back over it, right? Okay. We went over the requirement versus the violation, and this is important in stating your claim. How do I know if my contract is subject to TILA, so that we're not getting our cases dismissed because we are saying, oh, well, they have to abide by the law, and the contract not even governed by TILA. So this is how you know if the contract is governed by TILA. The finance charge, very, very important. The insurance was supposed to be included in the finance charge. That is the biggest thing that they leave out. They don't include that in the finance charge, which is supposed to be included in the finance charge. Charging a down payment where no cash should be included. Once again, misrepresenting the amount financed. Because if the bank required it, which we know they didn't because you called, hint, hint, it should have been in the finance charge. We went over 15 USC definition of finance charge and 12 CFR definition of finance charge that breaks it down even more in depth. We went over the down payment itself, just the even advertising of a down payment, right? We went over the 15 USC's definition and the 12 CFR's definition of advertising of down payments. Once again, if it says the only way that they can advertise a down payment is either no down payment or no trade-in required. Other than that, it has to be separate disclosures for that down payment, and they didn't give you a separate disclosures for your down payment. There's nothing to disclose because that down payment went into their pocket. It didn't lower the cost of the vehicle. If you notice that, it didn't lower the cost of the vehicle. They say that. They're liars. We went over the contract. That H1 credit sale model form, that's what's supposed to be in your contract. The definition of a finance charge located on the H1 model form. Where did they get that definition from? 12 CFR 1026. Consumers' claims and defenses. This is really important because we went over who's responsible, who we can go after if we find violations and fraud in our contract. It says we can go after the holder or the seller. But in order to get our down payment back, we're going after the dealership. Consumer credit contract definition, because you need to know that your contract is a consumer credit contract. And 16 CFR 433.1I tells you that. We went over stating your claim, how important that is, making sure that somewhere in the law they are civilly liable and criminally liable to you for violating any law under that subchapter. Failure to state a claim, very, very important. Your liability is going to be under 15 USC 1640 when it comes to your down payment. Example of how to state your claim. ABC failed to comply with 12 CFR 1026 and is civilly liable to me under 15 USC 1640. When stating your claim, you have both the requirement and the violation and where they are civilly and criminally liable. This is another requirement that the dealership didn't uphold if that notice of the holder is not in there. This is where your relief is going to be under that 15 USC 1640. You have monetary relief and you have equitable relief. You're going after monetary relief. You want your money. And then we went over all the rebuttals that they could possibly say, right? We know what they're supposed to do. And then obviously they're going to give you some pushback. Your agreement, you promised to pay. You have to have full disclosures. If I'm going into something and you didn't fully disclose to me something and you were supposed to, you can't, no, the contract is now void because you didn't follow this contract does not uphold the CFR standards and it does not uphold the USC standards. So if I don't know that and I find that in my contract, I'm able to then go after you. That's why they have to put that on there. That rule, that 433.2 rule, they have to put that in there. Okay? They gave you a loan. We already went over that. The CFPB says the retail installment contract is not a loan. Okay? And this is the law that they'll be violating if they say that for false and inaccurate information. They are not the creditor because they'll say this because they don't want to be held liable under TILA. But 16 CFR 433.1C says they are the creditor. They don't fall under the FTC holder rule, and that is the rule that states that the holder and the seller, that the debtor, you, are able to assert your rights and come after them. Okay? And that's here. I'm sorry, y'all, 433.3. I said 433.2 in the last slide. Insurance was not supposed to be included. That's going to be a big one. Once again, if the insurance wasn't supposed to be included, where's the disclosures at? Where's the disclosures at? And if it was supposed to be included, or and 9 times out of 10 it is supposed to be included, because 9 times out of 10 state law almost always requires property insurance. So either way, you're lying. If it's supposed to be required, it should be in the finance charge. If it's not in the finance charge and you took cash for it, especially where cash wasn't supposed to be taken in a consumer credit contract, you're in violation again. And then 12 CFR 1026-4D is disclosures of insurance, right? This is where it states that they're supposed to disclose the types of insurance to you. You agreed to pay, and we went over how you paid, right? That consumer credit contract, any instrument which evidences or embodies a debt arising from a purchase money loan or a finance sale as defined in paragraphs D and E of this section. So that consumer contract was that retail installment contract, right? Then you went down to financial asset, means cash or a contract or instrument that conveys to one entity a contractual right to receive cash or another financial instrument from another entity. That contract, right? The contract gave the dealership the right to receive cash, did it not? When you signed that contract, you walked off the lot even though you didn't physically give them cash. You didn't physically give them, $30,000 or whatever your car, they said it cost. But that contract was just as good as cash. Then we went down here. And to make it easy for you, because it took me a minute to find it, but I'm going to cut that down to a couple seconds for you guys. You're going to go down to 3 to payment, and you're going to paragraph E is where it says it. Purchaser evidences of indebtedness payable on demand or readily tradable. Evidence of indebtednesses. When they told you that you owed so-and-so, that was evidence of indebtednesses payable on demand. It was payable on demand because, once again, that contract was just as good as cash when you gave it to them. It paid for the car. Okay? Treatment as payment. These right here, evidence of indebtednesses payable on demand, treatment, it should be treated as a payment. That's where you're going to find that here. And that is the end of our class, y'all. It's not hard at all. Those are the things that you're going to study when it comes to everything. I did put this in PDF form with the links so that you guys can click it. You guys can rewatch this video as many times as you need to. If you want to, like I said, you want to do it in PDF form, you want to read it, you can do that as well. And you can click the link so that it's easy to find these laws. You don't have to go searching for them. Because I know a lot of the times you can miss one little letter or something like that, and it'll bring you to another section of the law. So I wanted to make it easy in that way. But that is literally the gist of everything, y'all. Read, study your contracts. Please highlight all of the violations in your contracts. Know that they are committing dealer fraud. More importantly, they're committing securities fraud. And I will do a car contract class. I will do a brief one on YouTube that's going to be free, and we're going to go over your contract, your car contract, and then I am going to make a class that's going to be premium paid content where we go over how to get out of your car contract in general. So this was about your down payment, get your down payment back, but you can also go after the financial institution as well, and we're going to go over how to do that. So thank you for attending this class, you guys. I will see you in the next one.